Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she goes, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog gave it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
All caps means you're either panicking or trying to represent yourself in court. Both are mistakes. Your feelings are adorable, but they're not admissible, persuasive, or even interesting without evidence. Yes, Heather hates immunity doctrines. It's a personality trait at this point. You don't need to remind her, she wakes up angry about it. Bring receipts. No, I heard it from so and so. This is quid pro quo, not next door. Screenshots are statutes only. Don't fight each other. Fight the law. It deserves it more. If you're offended, excellent. That means you're awake, paying attention, and probably new here. No diagnosing the host. She's petty, not pathological. And don't diagnose anyone else. Stay in your lane, please and thank you. Do not summon the mods. They're tired, hangry, and may bite when provoked. Disagree loudly if you must. The algorithm eats drama for breakfast. Just keep it cute while you argue wrongfully. If you're taking screenshots of my chat, touch grass, tell your handlers. I said hi and find a hobby that isn't me.
Hey everybody. So before we get into today's monologue, shall you say, I have a couple of interesting documents to show in another case. So we're gonna get into this stuff first, before we get into the Hannah Dugan stuff. And there was a Hannah Dugan a letter to the judge that was filed today, a few minutes ago actually, and we'll read what that has to say because I haven't read it yet. But we have this interesting piece of so basically this is a sanction form in the Second Judicial Circuit in and for Sumter County, Florida, State of Florida versus Gabriel Weeks. If that rings a bell. Maybe that rings a bell. Um, it appears defendant has materially violated one or more conditions of probation. The offender will be subjected to bi-monthly urinalysis tests. The offender will also be required to complete a drug and alcohol evaluation and complete any recommended treatment on the first attempt. So it looks like someone broke one of the issues of the requirements of their parole. So let's share this one. The 10/24/25, first date of violation. First violation. Um Anybody wanna it's not really breaking news, it happened last month, but I was just sent these documents and I was like, "Oh, I'm going live, so let's just bring this up first. Violation of condition 5 of the order of probation by failing to live without violating any law, and as grounds for belief that the offender violated his probation. The offender was in possession of a drug or narcotic not prescribed to him by a physician, to wit, cocaine, as shown by analysis of urine sample from offender on 10/24, as confirmed by the offender's admission on 10/24. Naughty, naughty, naughty. The offender will be subjected to bi-monthly urinalysis drug screenings. The offender will also be required to complete a drug and alcohol evaluation and complete any recommended treatment on the first attempt. But this is where I thought that it got super interesting. Because, like that shit happens all the time. People do stupid shit. Um, no, well, we're gonna get to that. That'll be either tomorrow or Monday. Like I said, I took off Wednesday for reasons, and yesterday being Thanksgiving, I'm behind on all sorts of content. But we have this. This is what I thought was extremely interesting in regards to this whole situation. We are going to let me whoop. Let's do this and that. There we go. So, Lisa wrote a letter. It says, "Miss Simpson, I have attempted to send you this email several times. I'm writing to you regarding a case you prosecuted against my husband, Gabriel Weeks. I understand that you are not the prosecutor at his arraignment. However, I wish you paid attention to what took place at the arraignment." Oh, sweet pea. Sweet pea. If you ever want a prosecutor, a judge, or anybody to be on your side, this is not how you speak to them. Whether you like or you hate somebody, this is not how you speak to a court official. And we had that debate on whether Florida sees prosecutors as officers of the court, but this is not how you speak to a member of the judiciary branch of government, because this is just fucking ridiculous. Attached is a video of Gabriel's arraignment, which clearly shows the judge pointed out that this was not a criminal, but a civil. Also attached is my letter. Please review it. What does that have to do with parole violation? Gabe has been on probation for nearly 2 years over this. His rights have been taken away for someone claiming to be a victim and lying about what happened. Oh, plain victim. Plain victim. Oh, yeah. My husband stole nothing. There was never any grand theft. Just to make the traveling to Daytona stop, he gave up and agreed to your deal. That's not what the court docs say, but okay. Since then, his reputation has been harmed, and he has been publicly dehumanized, harassed, and ridiculed, along with myself. This has caused defamation, slander, cyberstalking, and is affecting our mental health. This was badly handled and could have been easily sent to a civil matter. Well, you just said it was civil, and I mean, or his ankle bracelet. Well, that too. Well, here's the thing. This was not a criminal case, but civil. But you then up here you say not criminal case, but civil. This was badly handled and could have been easily sent to a civil matter, which you just which one's true, lady? Which one's true? Which it actually is. I'm asking that you review my letter. No, grand theft is criminal. Grand theft is not a civil matter. Theft is not a civil matter. That is a crime. So therefore it is criminal. Like I'm not a lawyer, but like for someone who uses a legal who has legal in their email address, you sure don't know much. I am asking that you review my letter and the attached video of the arraignment hearing and listen to the victim clearly stating how this is civil and not criminal. You charged my husband with multiple false charges just to win points. We want this case dismissed, and the supposed victim wants he can file a civil suit, or your office can transfer to a civil case, however that works. It does not work like that. This is not how this works. Yeah, and oftentimes there is this thing about like even if someone doesn't want to press charges, the police or the prosecutor will still press charges when they know a crime's been committed. Like if you say you take your hand and you use it to close your fist and make it a certain thing towards somebody in front of a cop. I have personally witnessed where you will still get prosecuted despite the person that got punched saying, I don't want to press charges. The cops are like, too bad, I saw it. You know? But yeah, so that was and then you can reach me at this email or contact me at, well, here's the thing, Lisa, you put your phone number in a I I was respectful enough to block it out, but that's her phone number. So whenever you send anything to the court, and especially ex parte, expect them to put it on file. When they put it on file, it becomes a matter of public record. So anybody who sees that record now has your phone number. That's not a good idea. That's not a good idea. Like if they want to call you, they will figure out how to get a hold of you. You don't have to give them your phone number because this was this was filed. Copy sent to state attorney, copy sent to defense counsel or the PO in this case, not read ex parte. So the judge didn't even read this. This was sent to Judge Elizabeth Blackburn. She did not read it. So there's that. I just figured we'd get that out of the way. And you know, these idiots should have thought of all that before they started attacking other people. Well, as far as what was in here, I don't want to dox anybody because I just don't. Because I'm all for treat people how you want to be treated. I don't want people to dox me, so regardless of how I feel about them, I just don't try not to do it. Sometimes I miss a thing here and there, and it's not on purpose. But it's a matter of court records now. So anybody who views that court record, and it's easy to find, it's Volusia County, like it's not hard to find, now has her phone number without working too hard. All right. So before we get started on today's stuff, Hung Hero, thank you for the 50 gifted Squid Pro Quo memberships. So if you got a gifted membership, thank Hung Hero. He is the unsung hero of this chat and turning it green and also outing people. It's funny. Hung Hero, thank you for the $2 super chat. Happy Turkey Day. Thank you. I hope everybody had a good Thanksgiving if you were in the US. And if you are not in the US, I hope you had a good Thursday. And Jeffrey, thanks for the $2 super chat. Turkey, shoot, clay pigeon, have fun at the range. Oh my goodness. Thanks, Jeffrey, for the $2 super chat. And Jen Thunder, thanks for being a member for 6 months. Hope you had a very happy and safe Thanksgiving. Yeah, we just stayed home. It was good. It was quiet. Yeah, isn't it? Well, 2 years later after he pops on a piss test. I don't know, but I'm sure she annoyed a bunch of people. Yeah. Yeah, DV cases, especially if a partner refuses to press charges and the cops see any marks, the state will press charges. Yeah, that, you know, it's one of those things of like, you don't, the person who presses or who was the victim doesn't always have to be the one to say, yeah, I want to press charges. Sometimes the judge can just, not the judge, but the criminal justice system can do it for you, especially if they're a witness. It's kind of like that mandatory reporting thing. Anyway, to what we are speaking on today. Oh, good old Hannah. I really don't know what to say about this. When I was writing what I was going to say about this, because I've kind of started doing these little monologues, and it's actually kind of fun. It's like Judge Adelman walked into her courtroom, read these motions, took a sip of her coffee, and said, "Not today, Satan." She is not taking crap from anybody. Even though Judge Belatho, I'm still on your side. If you happen to see this and someone puts it in a motion or something, take note. Judge Adelman not taking crap from anybody. Not the U.S., not another judge. She's not taking crap from anybody. It's her courtroom. She's going to run it the way she wants to. And if you don't like it, tough shit. She denied immunity again. She's blocking the political theatrics, shut down hearsay shenanigans, and basically told everybody that you are not the judge. I am. If you don't like it, too bad. So we are going to get into the documents, and we are not going to go too deep because of the fact that a lot of this we had covered. So we're just going to go basically into what she did or her decisions. She has it broken down. This judge writes very interesting in the sense of the way she has things broken down is very easy to read. But she basically went through everything A, B, C, D, E and said denied, request or request denied, request granted, anything like that. So, yeah, clearly Lisa is blaming Jeremy Hales for a failed piss test by her hubby. Yes, I'm sure that one, if the mental gymnastics that she would have to do to make that plausible. Like, oh my goodness. All right. Government's motions. So decision in order. We'll get into this. The government charged Hannah Dugan with concealing a person from arrest, obstructing removal proceedings from the Department of Homeland Security. The government alleges April 18th, defendant, a state court judge, concealed from arrest and obstructed the apprehension of a person, EFR, wanted by federal immigration authorities for removal. The case was set for trial on December 15th, 2025. This order addresses the parties' motions in limine. All right. The government filed a consolidated motion in limine, making 13 requests, as well as an additional motion to bar defendant's proposed expert testimony. I address each in turn. The consolidated motion, potential punishment, collateral consequences. Government moves to preclude defendant from mentioning potential punishment. Defendant does not object. Request is granted. Jury nullification. This one I found huge. That's a problem. And that's a problem. And see, I am personally under the guise that if you have to hide behind your immunity for something in a lawsuit or a criminal charge, you know that you did something wrong. If you have to hide behind immunity as to why you did something, you know that you morally fucked up. During nullification, government moved for an order precluding defendant from presenting evidence or argument to induce jury nullification, as they should. Defendant does not object to the government's request to prohibit her from arguing for jury nullification or appealing to jurors to decide the case based on their personal views of immigration policy and enforcement. And this case has never been what my audience feels about the immigration laws. My feeling on that has always been we need to, if we hate the laws, we need to stop not enforcing the laws and start telling Congress to do their jobs and change the laws, because that's what they do. That's what they're supposed to do. However, this whole due process thing of people not getting due process for removal to the country, I believe there was something signed by Bill Clinton in 1996 that had basically removed um, the need or the requirement for due process as expedited removal. So anybody on a certain side of the aisle complaining about a certain person in the White House right now not giving due process, you can blame Bill Clinton for that. I have the statute somewhere on my computer. I just cannot figure or find it at this very second. I have too many windows open. However, I just thought it was interesting. 1996 Illegal Immigration Reform and Immigrant Responsibility Act allows deportation without a judicial hearing through a process called expedited removal. September 30th, 1996. Like I said, if you hate the laws, don't blame the person enforcing them. Blame the people who made them. Or blame the people who aren't changing them. Don't blame, it's like, don't blame the, it's like, don't shoot the messenger. Change the game. But for me, this case is more about people hiding behind judicial immunity, and also people that are constantly on Twitter going, nobody is above the law, nobody is above the law, nobody is above the law. But when someone is charged with a crime for breaking said law, all of a sudden everybody's up in arms. So my thing is about, like, what are people finally being held accountable, and will this take judicial immunity away? Will we start looking at judicial immunity now and being like, this has gone too far? It has its purpose, but it's gone too far. Clinton immigration reform allows expedited removal for those previously deported or has outstanding deportation orders, which EFR did, because EFR is gone. By the way, in case anybody cares. Discovery requests. Government moved to bar discovery requests, commentary regarding discovery in presence of jury. Defendant responds that she is not opposed to this general idea. Obviously, however, both parties will be commenting on discovery throughout the trial. For example, a question and answer comment during the trial that a document was produced by the government is proper and necessary, as may be the timing of that production. With that understanding, the request is granted. So many places to take that one. I mean, I know I don't dress great, but I don't look like Kim Jong-un either. Yeah. That's a whole can of worms that we're just not getting into. Reasonable doubt. Government moves to bar the defense from defining reasonable doubt. Request is granted. The only person who should define reasonable doubt is the judge. Defendant's out-of-court statement. Government moves to preclude defendant from eliciting her own out-of-court statements, including self-serving statements she made to police officers April 22nd. Government argues that such statements would be hearsay. Rule of completeness would not require their admission. Defendant responds that without additional context or a more specific request, it is difficult to respond to this motion. She notes out-of-court statements are not necessarily hearsay, and that statements offered for relevant purposes other than the truth are not hearsay at all. I have so many things to say, but it's also almost the start of the Georgia Tech game, so we're getting through this a little bit fast. Defendant's out-of-court statement, when offered by the defense, is generally hearsay. U.S. v. Pulliam. Seventh Circuit also noted defendants often try to justify their own actions when speaking to the FBI agents or other law enforcement officials English is hard, by disclaiming criminal intent. Such an exculpatory statement has nothing to do with Rule 106, rule of completeness. U.S. v. Smith. In those circumstances, the appropriate vehicle for introduction of such evidence is for the defendant to take the stand and testify that she did not think she was doing anything wrong, rather than using Rule 106. Without knowing the precise statements defendant may seek to introduce and why, I cannot issue a definitive ruling. Defense counsel should alert the court prior to introducing such statements and be prepared to explain the basis for admission, consistent with the standards set forth above. This judge is not handling hearsay. She's like, I don't give a shit. This judge, I feel like, tried to use the fact that she was a judge and like, hey, you're a judge, I'm a judge, we're buddies, right? No, bitch. No, bitch. That's not how shit works. And this judge is like, I don't know you, get away from me. Since when does the defendant get to set their own rules of discovery and proper evidence? They try to argue shit all the time. Motives of law enforcement. Defendant or the government moves to bar argument or questioning concern of the motives of law enforcement to enforce the laws. Defense team has claimed to reporters that the case is an attack on the independent judiciary and is politically charged. This is the problem. No one's been held accountable for breaking laws for so long that now that someone's being charged, it's all political. It's like, no, sometimes it's just, here's the law. You did something that we believe broke the law. We're going to charge you. It's not, if it's criminally, but sometimes if people go, it's politically charged, it's like, you might want to look in the mirror. Because the people who are always saying that things are political are the people that always make shit political. To a hammer, everything is a nail. So when you're always the one screaming, it's like the same people who are screaming Yahtzee, misogyny, the patriarchy, America's bad, this, that, are always the people who wake up angry on a daily basis. It's like, the rest of us are just kind of here like, yo, what the hell are you doing? The rest of us are just, Yeah, the only people complaining about laws being enforced is when laws are being enforced against Democrats. I hate the double standard. And they go, well, laws aren't being enforced against Republicans. Well, here's the thing. Maybe they are, but maybe most people aren't breaking those laws. So technically they are being enforced, but they don't have to be because no one's doing anything wrong. It's like the harder certain people dig to find dirt on a certain person, the more like dirt they get on themselves. It's just, ugh. Do you believe she's trying to have this in the court of public opinion? Yeah, anytime you speak to the media first, anytime you try to speak to the media before you try your case in court, it's different if you win a case, like Johnny Depp won his case finally after all these years, and then did the, media tour going around with his lawyers. But when you get on TV almost immediately, and that's what she did. She went on WISN 12, and I think Fox, she did the media rounds in Milwaukee and tried to make it seem like she tried to win in the court of public opinion. And anybody who has anytime that I saw this, anytime that people need to try things in the court of public opinion, like, I don't know, going on freaking YouTube channels and talking for 7 hours, or writing letters to the court ex parte instead of just letting the judicial system. Our judicial system is not perfect. However, it is definitely could be worse. With that being said, let's get back into this. I'm leery of anybody who instantly runs to the media to talk on their behalf. Instantly. If you get nowhere with the court system and you're having problems with the court system and you need someone to advocate for you, so you go to, I don't know, a certain journalist and go on her YouTube channel to try to get attention brought to your case because the judge in your case is being a douche canoe. I get that. I can understand that because it was tried in the court first and it didn't exactly work. Well, one of the things that I like to do is kind of see how certain things, certain behaviors, certain things that we've seen in that case, how it's handled elsewhere, how it's handled in different courts. Because I've noticed things on both sides that are getting kind of crazy. Like the advocating for or the encouraging people to be irresponsible with, I don't know, money is not just limited to the anti what the hell side. It's also on the what the hell side. Maybe not with creators, not with all creators, but with certain people in their Pacer accounts. I have seen a document that has a $7,000 Pacer account, $7,000 Pacer bill. With that being said, you can't keep encouraging this person to be irresponsible with Pacer and getting your bill up to $7,000 and encouraging that behavior. I'm hoping that this person just doesn't know any better, but I'm also upset that people who know how to use that system haven't sat down with him and said, hey, this is awfully high. The rest of us have Pacer bills that are like $100. My Pacer bill, and I'm following this case, I'm following 6 cases that are not related to what the hales, and my Pacer bill was $132.60 for the last quarter. So with that, for all of this, like I feel like I need to do a how to run Pacer effectively and spend the least amount of money and get the most results. But things that I'm seeing on the anti what the hale side are not limited to anti what the hales if you take a step back and you look at behaviors on both sides. And it makes me very upset. It makes me very upset from like I'm not personally involved. I don't talk to any of these people. However, it kind of does from a human perspective to watch somebody, even though I might not like somebody, to watch them being taken advantage of and seeing comments of people encouraging them to be irresponsible with money. It's hard to watch. But if you take a step back and you watch both sides equally because you don't have a personal stake in either side, you can see behaviors on both sides that are exactly the same. But yet one side claims to have the moral high ground and the other and always says the other side is degenerate. I'm not saying that one side is good. One side is good. But it's a microcosm of greater society. One side always calls the other side horrible things, tries to claim the moral high ground, but isn't exactly the greatest people themselves. Yeah, no. Thanks for lying for me, Dad, but no, I don't discriminate. I hate everybody equally. I'm just that kind of person where if I don't like you, I just won't talk to you because it's like it's just not worth the time and effort. However, if I'm still going to call it like I see it, and I don't particularly like the person who's being taken advantage of, but I believe they're being taken advantage of, and they won't listen to me because they'll think I'm lying to them, which is fine because they can think whatever the hell they want, but it's so Pacer, for those of you who need like a rundown on Pacer, it's 10 cents per page. However, every time you run a docket search, that still counts as a page. The docket for federal one, if I were to run the whole federal one docket right now, it'd be over $3. But there are ways to do it where you only search for like, hey, I know that document 170 was the last one filed. So I'm going to look for document 170 to 200. And you limit the amount and you remove terminated and filed parties and you limit. So I can run a docket search for documents and pay 20 cents. But if you click it, also save your documents. Save your documents. Save your documents. I am so like I am so upset that this person is being taken advantage of by a lot of people. And the fact that the average person in chat does not realize that and is encouraging them, you do great work, you do great work. Yeah, while spending $7,000 in one quarter. Like, I don't, and I know you're watching because you're the one who takes screenshots and sends them to Jeremy and sends them to Megan and Tug and whatever. DM me or whatever. I don't have you blocked. DM me. We can do a pacer where you can get the documents for cheaper. I will show you how to use it where you don't pay that much money. Yes, and if you don't save it and you run the document. So I paid $3 for this document. It's 21 pages, $2.10 plus the cost of the thing. So overall, for the documents I got today, I paid like $3-ish. Which hopefully I will make up in ad revenue. Hopefully. And that's one of the reasons that I monetize my streams, especially ones where I'm covering documents, is because I paid for these documents. And since I don't rely on super chats, I monetize the stream so that I can make my money back. With that being said, I save the documents and I even tell you guys, hey, I got to make sure I save this because I don't want to pay for that document twice. So if you're not saving the document and you're running these document searches like 6 times a day, that's like, oh my God. Spawn, we were just doing a little pacer, how to save money on pacer education. Like because I don't have to like people or get along with people or people can hate me all they want, but I'm still going to call BS when I see it. And I don't like people being taken advantage of, even when I'm not a particularly fan of them, but I'm still not going to be the dick. I'm going to act like Spawn Trooper. Get back on topic. All right. Getting back on topic. Motives for law enforcement. Defendants object to this request. She notes that the indictment alleges the agents planned to arrest EFR in a public hallway, but their plans apparently changed, and they ended up arresting him outside the courthouse. Yes, and we got into the why of that. Best laid plans change. Since when? Okay, I don't know if any of y'all have ever been law enforcement, or Jeff, you can answer this one. So I'm assuming that law enforcement goes in kind of like the military. Like you make a plan, or even breaking it down even further to something I know, like a therapy. I go in with a plan, and best of intentions and best laid plans don't always go to plan. And sometimes you have to wing it, and you have to do what works instead of what you wanted to do. It's not an ideal situation, but your plans are the ideal. If everything goes to plan, this is what we will do. Shit doesn't happen. Nothing ever goes to plan. So her bringing this up is like, are you that stupid? Like, are you really that stupid? Are you really that stupid? The defendant contends, puts the agent's intentions and motives at issue. Defendant further contends that the government made a rushed charging decision, which required the agents to attempt to fit their investigation to the previous charging decision. To the extent the agents deny their planned change, in contradiction to the record evidence, Judge Dugan should be able to demonstrate and explain to the jury why they are motivated to change their stories. I do not understand. I do not understand defendant to argue that she should be permitted to argue to the jury that prosecution is politically motivated. U.S. v. Johnson. Defendant alleges that the indictment was a political instrument in soliciting defendant's cooperation with the FBI probe of the CETA program and the DEA drug investigation centered upon the Black community. Had the judge, in his discretion, permitted excursions into extraneous and collateral matters unrelated to the particular drug transactions, the trial would have been delayed and the issues confused. Both sides will be allowed to present relevant evidence regarding what happened and why. My military plan was to do 4 years free college. For free college, I derailed myself and made it a career. Well, okay, like, everybody I mean, common sense, Devil fan. Common sense. It You always make a plan. You always go in with a plan to whatever you do. Hell, I go into the little's room to get her dressed in the morning with a plan, but that shit never goes to plan. So you have contingencies. Okay, if this doesn't work, we're gonna do this. If this doesn't work or if this happens, we're gonna do this. I'm like, it can't be much different with anything else, especially law enforcement. You have a plan and you have contingencies. That's why I'm like, uh, yeah, does everything have to be politically motivated? It's like the people who are always saying everything's politically motivated or this or that all are looking through the lens of politics. To a hammer, everything is a nail. To someone who is racist, everything seems racist. Like, I'm sorry, when people are, like, defending illegal immigrants being here, and they're literally like, "Well, who's gonna" I saw a tweet the other day of a place in North Carolina, the construction site. "Well, before ICE got here, everybody was working, now they're all staying home." I wonder why. What are we gonna do? How is our infrastructure gonna work? You're gonna hire freaking Americans. I mean, I don't s like, what but that costs too much. So you're admitting that you just hired those people because it's cheap labor. That's racist. That is the definition. Now I need, well, apparently not neither are judges, neither are lawyers. Um, I'm gonna need, now I'm really gonna need those super chats, Devil fan, because I think I just, you know. Yeah, but the thing is the people there was somebody on Twitter the other day that was like, "ICE coming in here is so racist." Like, and you just admitted that you have them work because they're cheap labor. That right there is the definition of racist. Who's gonna clean my toilets? I don't know. Maybe someone who owns a cleaning company, who's legal. Like, I know a guy, um, my boss. Like, I know a guy who owns a cleaning company. Like, it it's just, it's just, yeah, it's just a situation where it's like you just basically let everybody know how stupid you are. Uh, Alright. Requirement of a judicial warrant. The indictment alleges that defendant falsely told ICE agents they need a judicial warrant to arrest EFR. Government argues defendant should be precluded from arguing that a judicial warrant, as opposed to an administrative warrant, is needed to arrest an alien in a public hallway. Indeed, the government contends the evidence will show that the defendant has reason to know that an administrative warrant was sufficient. And Fletcher Boy, thank you for the $9.99 super chat, Pacer Fund contribution. Thank you. It's today is paid for. These documents do add up, but you try to do it in a way that does not isn't you're not stupid with it. Like, you don't want to be irresponsible with getting documents. That's why I don't check the docket like 6 times a day. Sometimes I'll check once a day, and then if I hear something or somebody says, "Hey, there might be a new document," then I'll check again. I don't just check to to check because it costs money. Even 10 cents here, 10 cents there, if you're checking it 10 times a day. Like, I got, need to put gas in my car and food on my table and stuff like that. Defendant objects, noting that government made this an issue by alleging she committed obstruction by confronting members of a U.S. ICE task force and falsely telling them that they needed a judicial warrant to effectuate the arrest. The indictment also alleges defendant knew a warrant had been issued. Evidence of what Judge Dugan knew will overlap significantly with what was actually true. Defendant does not present contrary authority on the issue whether a judicial warrant was actually required here, but the indictment does make what defendant knew relevant. Both sides should be permitted to present evidence on that point. The arrest. Government seeks to bar evidence argument concerning defendant's arrest, alluding to alternative means of bringing her to court of initial appearance. I'm sorry, you're a judge. You aren't special. You weren't special. You got arrested just like anybody else. Why should you be snuck through the back door for your initial appearance or do it through Zoom? Nobody else is afforded that, so why are you? She's asking for special treatment. Defendant objects, arguing she must be permitted to discredit the caliber of the investigation or the decision to charge her. In the briefing, or the footnote, in the briefing on her motion to dismiss, defendant stated, assuming she said what the government claims now, Judge Dugan probably was wrong about whether an ICE administrative warrant meets Fourth Amendment muster, but that's not entirely settled. Oh, it's all on camera. I sent you a photo of a case I worked involving a whole lot of plan changes on the fly. Oh, no. Oh, no. Oh, no. Oh, no. Our very own Jeff Grady here got a citation. Outstanding service to the sheriff's office and the citizens of Orange County. I'll have to read that later, but you, yeah, but you can medicate. You can medicate it. Defendant should be permitted to challenge the integrity of the investigation. However, it's unclear why this would include evidence about her arrest. Absent further explanation as to how this could be relevant, the government's request granted. Well, she's asking for special treatment. They arrested me in front of the people. They arrested me in public. Well, guess what? You're a person. Suck it up, Buttercup. Duration of the investigation. She basically said that it was too short of an investigation. So basically she's not denying or proving it. Says the balance will be struck at trial. Success in preventing EFR's arrest. This is I was a shitty criminal, therefore I can't be held liable. If everybody remembers that. The government moves to bar argument the defendant should not be convicted because she did not succeed in preventing EFR's arrest. No harm, no foul. The government cites authority that neither the charging statutes require the defendant to succeed in concealing the person or obstructing the proceeding. Yeah. It's almost like, and I think it was Jeffrey Montgomery who said it last time, or messaged it to me. Attempted unaliving someone isn't a crime because they didn't succeed. Make that make sense. It's like the mental gymnastics that some of these motions have. I'm like, yeah, there's no basis in logic there. Special treatment for a criminal. Don't all criminals ask for the same special treatment? Maybe she's ADA protected. She's not Laura Owens. Oh my goodness. Defendant objects, referring to her proposed jury instructions, including an element of materiality. Additionally, government alleges defendant corruptly endeavored to influence, obstruct, and impede a proceeding. Oh, and they were going to bring in an expert to define proceeding. That's where that judge was like, no, 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 no. The arguments that may be made to the jury will depend on the court's instructions yet to be finalized. Defendant will be permitted to present evidence and argument that she did not endeavor to instruct the arrest. I will otherwise defer a ruling on the request number 10 at this time. Other ICE actions. Government moves to bar evidence of other ICE enforcement actions in the Milwaukee County Courthouse or elsewhere, arguing that except to impeach a witness or show bias, such collateral evidence has no relevance to the events of April 18th and should be excluded from the jury's consideration. Defendant objects, arguing previous ICE arrests at the Milwaukee County Courthouse and the evolving policies set forth by the chief judge are directly relevant to her subjective mindset on April 18th. Your mindset is TDS, 3 letters, simple, easy to define. When it comes to sentencing, I worked in corrections and have seen murderers get less time than the guy who was caught with weed. Yeah, that's yeah. Yeah, it's freaking ridiculous. Like, just because you suck at being a criminal doesn't mean you aren't a criminal. You're just a stupid one. I don't know how else to describe that, but I agree with defense that such evidence may be relevant to the defendant's mental state. This request is denied. Defendant's alleged good motives. Government must prove she had corrupt motives or a corrupt intent. Her motives are therefore relevant. Absent more specifics, I cannot definitively rule on this request. Defendant will be allowed to present relevant evidence touching on her mental state. Defendant's prior good acts. I've never been a criminal before. All it takes is one time, sweet pea. Government moves to bar evidence of defendant's prior good acts, noting she may seek to introduce evidence of her past law-abiding conduct. I don't think anybody should be able to do this because this is just prior good acts. It's like, so you never got caught. Or so you just weren't an asshole. Being an asshole, by the way, is not exactly illegal, but this one makes me laugh because I'm like, so I'm 40. Say I had to go to court tomorrow for something. I would tell the judge, well, I've been a good, a good person for 40 years. I shouldn't be charged with whatever. It's like, that's not how this shit works. No, remember the emails from the chief judge about all the ICE people in Milwaukee at the time? Dugan cannot say she was mental one. No, it was they're referring to mental state as far as like the emails from the chief judge and what the policies were, even though the chief judge can't actually make policy because that's not his job. That kind of stuff. So she had so with that, I'm not siding with Dugan, but when they refer to mental state in here, they're referring to her thought process and what she was thinking at the time, not psychotic. Yeah, I worked at a bank for 30 years and didn't steal money in all that time. Don't put me in jail for the one time I stole $100,000. I know, right? It's like I worked on Wall Street for 20 years and I never embezzled any money. I just am not. I only did it for 6 months. I've never done it before. That suddenly makes it all better, right? Oh, it's applying that logic to other situations just does not. It just doesn't. Oh, when you apply that logic to other situations, it just makes you want to like cringe. Exactly right here. Um, And there's case law. Defendant may not seek to establish his innocence through proof of the absence of criminal acts on specific occasions. Defendant objects to this motion because it's unclear what the government is attempting to exclude here. Your entire life that you've told the media. I will defer ruling at this time and consider the issue if it arises in the context of specific evidence. Expert testimony. Oh, here we go. The government moves to exclude proposed expert testimony from an immigration lawyer regarding the meaning of certain statutory and regulatory terms pending proceeding. The government contends that the meaning of the term proceeding is a question of law to be decided by the judge in the context of jury instructions. Seventh Circuit has consistently held that such testimony may be excluded. I'm interested to see what she has to say, not like case law. Much of defendant's responses discusses whether there was a pending proceeding before the Department of Homeland Security on April 18th, as alleged in count 2. The defense does not believe that the government can factually satisfy the requirement. The proffered expert testimony seeks to assert the underlying facts relevant to that inquiry. Those facts include the nature and extent of a second party involvement when an expedited removal proceeding has been completed 12 years earlier, as well as the lack of a second party involvement in the issue of the warrant. Defendant agrees that the court will define the law for the jury, including apparently the meaning of the phrase proceeding before. Oh my god. It's unclear how a proposed expert will provide evidence as to the facts. The government has indicated it will have ICE witnesses provide lay testimony describing where the issuance and execution of the arrest warrant for EFR fit in his overall immigration proceedings. I will, at the final pretrial, discuss with the parties the permissible defense testimony, including from the proposed expert on this issue. Defendant's motion, the first one, official acts. This is where she hides behind her judicial immunity. Hi, Stephen from Melbourne, Australia. How is it on the other side of the planet? How are you feeling? Welcome to the shit show that is the U.S. judicial system at this particular point in time. This is where she hides. Defendant argues because lawful acts do and cannot obstruct or hinder under Seventh Circuit case law, the government may not rely on or even introduce evidence of these lawful acts. Alternatively, the government may not contest that they were official acts within a Wisconsin state judge's job. Oh, good old Wisconsin. Oh, Daddy, you ready to move yet? Even if it's permitted to argue that they were done corruptly. Ice. Stop. Now I'm gonna have that song stuck in my head all night. Defendant cites cases holding that an act one has a legal right to undertake does not obstruct or hinder. She cites all this case law. We've read her motions in limine in a past streams, so I'm not gonna get into all this case law. We're kind of skimming this because the football game's on right now and I really want to go watch. Hey, Mom. In these cases, the court recognized that corrupt interference with an investigation would not exist where a mother suggests her son invoke his right against compelled self-incrimination, a wife persuades her spouse not to disclose marital confidences, or a lawyer counsels a client not to turn over documents pursuant to a valid claim of privilege. Rather, the term corruptly requires a person to act with consciousness of wrongdoing. Defendant contends that because she had a legal right to do each of the 5 acts alleged in the indictment, all were within the scope of her authority as a Wisconsin state judge. There necessarily was no conscience of wrongdoing. She's turning this into her campaign. Yep. And the footnote is more of the case law, so I'm going to skip it. So Judge Dugan moves to exclude all government evidence that she impeded in any way hindered the scope of counts 1 and 2. This was hers. This was all stuff that she put in the in her stuff, in her motions. Finally, defendant renews her motion to dismiss based on basis of judicial immunity. That first motion in limine was not actually, in my opinion, layperson's opinion, not a lawyer, a motion in limine. I've read a lot of motions in limine, and that motion in limine was a motion for reconsideration of the motion to dismiss in disguise. She just repackaged it and put a different name on it. As the government notes, the defendant's motion in limine in effect confer partial judicial immunity and put much of the government's proof off limits. I agree that the correct approach is to permit the jury to consider all of defendant's conduct on April 18th in deciding whether she concealed an alien under 1071 or corruptly endeavored to obstruct a proceeding under 1505. The cases upon which defendant relies do not suggest a different result. As the government notes, Edwards and Matthews were jury instruction cases, construing the term corruptly to require wrongful conduct, not immunity cases placing official judicial acts outside the scope of the statutes. As I noted in denying defendant's motion to dismiss, there is no basis for granting immunity simply because some of the allegations in the indictment describe conduct that could be considered part of a judge's job. Could, not are. Also, her past statements in regards to immigration. So, because she had made how she felt very much known, and I think even had a sign on her courtroom door. So, yeah, there's that. But her immunity motion to dismiss due to immunity was already denied, and it's like you didn't put a motion for reconsideration, you just repackaged a motion in limine. It was dumb. All right. I decline to reconsider my previous ruling on the immunity motion or to adopt an evidentiary standard based on an official-unofficial distinction inconsistent with that ruling. As for defendant's second request, she will be free to present evidence and argument that the events of April 18th involved a routine work of a state court and judge. Ask people in the hallway how many times they've seen a judge in her robe out in the hallway talking to people. Not very often. And the government will be allowed to contend that defendant added extraneous activities to her usual duties in order to defeat enforcement of federal immigration law. With that understanding, defendant's first motion in limine is denied. Second was where she had all those 13. Sequestration, defendant moves to exclude non-party witnesses from the courtroom following their introduction to the panel of potential jurors, and to order all non-party witnesses not to discuss their proposed or complete testimony with other potential witnesses throughout the duration of the trial. The government does not object. The request is granted. Written instructions, the request is granted, consistent with the judge's standard practice. Roy, I'm not even touching that one. Character evidence. Defendant moves to prohibit the government from introducing any character evidence, including other crimes, wrongs, or acts from witnesses that has not been deemed previously by the court to pertain to an admissible purpose. To the extent this simply is meant as a request to apply to Federal Rules of Evidence 404, government has no objection. Request granted. Victims' rights. This is an interesting one. Defendant moves to prohibit the government from arguing or eliciting testimony that she violated Chapter 950, I can't read today, of the Wisconsin statutes, or Article 1, Section 9M of the Wisconsin Constitution, state victims' rights provisions. Arguing such evidence would not be relevant and would be substantially prejudicial. She further argues that allowing such evidence would create a mini-trial on an irrelevant issue. The government agrees there should not be a mini-trial about whether defendant violated Marcy's Law However, how defendant handled EFR's hearing and whether it was routine or business as usual, as the government contends, relevant to her intent. The government indicates EFR was charged with battery and his alleged victims were present for the hearing April 18th. Defendant handled EFR's case off the record without notifying the victims or the prosecutor. Anything that's handled off the record to me is ultimately I'm being shady. I don't know why. Yeah. Hey, Angie. It gets curiouser and curiouser. And the fact that she handled his battery case off the record without talking to the prosecutor or the victims. He was charged with domestic battery. Whether the treatment of EFR's victims was a routine practice or an aberration is relevant to her state of mind. Similarly, whether the treatment of EFR's victims was consistent with the guidance she received about Marsy's law is likewise relevant to her intent. I will permit the government to introduce evidence regarding whether the defendant handled his case in a customary fashion. This would seem relevant to her intent and the position she has taken throughout these proceedings. That all of the charged acts were done in ordinary course of a judge's duties. However, I will exclude, pursuant to Rule 403, evidence or argument that defendant violated Wisconsin victim rights laws. The probative value of such evidence is substantially outweighed by the danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, and wasting time. Relevant to the risk of confusion, the training memorandum upon which the government relies is equivocal regarding whether Marsy's law applies to off-the-record continuances. I don't see, and I have a problem with this. Nothing should be off the record if it's done in a courthouse. Oh my God. Oh my God. I'm just now reading the chat. Y'all crack me up. Roy, don't get my dad started. Like, my dad is a retired man now. Do not get him started. He's got lots of time on his hands to think about these things. And sometimes you is she related to Judge Grudge? No. Mama Squid and Papa Squid live in different states. Mama Squid and Papa Squid don't live together. Oh, that would be something. They haven't lived together in almost 40 years. Oh my God. I'm sorry, these comments are breaking me. Roy, don't get him started. Oh, y'all crack me up, man. I love this chat. Well, I am trying to get through this without too much of a derailment. Although I did start a new link tree. Derailed. I did start a new link tree. I will put it in the chat at the end. Let's see. Wee. There we go. I changed companies from Stan to Linktree. So there's that. No. My dad has more common sense than that. Jesus, people. Devil fan, you need Jesus. Blake. How are you today, Blake? How are you? Are you having as much time or a good a time at this as I am? All right. All right. The case law, again, I'm really only interested today because we did read all the motions in limine, but defendant's motion is granted as stated. So we're no wasting time. Personal beliefs. Defendant moves to prohibit government from arguing or questioning any witnesses as to whether they personally believe she is guilty that she committed the offenses with she is charged. The government does not object. As long as the defense is prohibited from doing the same, request is granted. Expert testimony. Defendant moves to prohibit government from eliciting undisclosed expert testimony. Government does not oppose. Request is granted. Administrative warrants. Defendant moves to prohibit government from eliciting testimony or a legal opinion from lay witnesses regarding administrative warrants. This is, as the government intends to call no expert witnesses, this request appears to be moot. Circuit court procedures. Defendant moves to prohibit the government from eliciting expert testimony from lay witnesses. This is expert testimony from lay witnesses. That's the kicker right there, because you don't get expert testimony from lay witnesses. I mean, that's Boone's Farm. The government responds that any testimony from a witness about court procedures will not involve expert testimony on a subject that's outside the ability of jurors to comprehend, but factual observations and perceptions from lawyers, court personnel, and law enforcement. To the extent this type of testimony relates to something the defendant views as court procedures, it clearly would not involve rendering an expert opinion on something requiring specific scientific, technical, or specialized knowledge. Rather, it would involve factual observations and some instances permissible lay opinions to explain why they took notice of certain conduct, like a judge out in the public hallway in her robe. It comes in a suitcase. Oh boy. Yo. It's called Saint Sarah of the Samsonite. It used to be cheap. It's probably not anymore. Government further contends that such observations and perceptions are relevant to defendant's intent. As indicated, I will give the government some leeway to demonstrate that proceedings in EFR's case were handled in an unusual fashion. It appears that the evidence offered in the form of lay opinion under Federal Rules of Evidence 701 may be a part of that presentation. The government intends to call no expert witnesses on the issue. Defendant's in limine request appears to be moot. He's asking a lot of moot points, and it's like, it's like, I don't know what to make of this judge and this judge's lawyer. I think this was the same lawyer that handled, and I'll have to do some more research, but I think this is the same. Her lawyer is from Manitowoc, and if that rings a bell, that's where Stephen Avery is from. However, she seems to be asking things that are like, duh, you're supposed to be a judge and you don't know how this shit works. You're asking for things like lay testimony from an expert testimony from a lay witness. You don't get expert testimony from a lay witness. That's not how that shit works. And that would be something that if they started asking testimony that would be deemed as expert testimony, the defense would just go, objection, expert testimony, or, crossing a line or whatever the thing would be. See the way the chat goes when Hales isn't the topic, when you have Squid giggling? Because this isn't supposed to be, this is ridiculous. And I hate immunity. I hate immunity. You saw it in my petty chat rules. I hate immunity. I hate all sorts of immunity. But, yeah. Attorney General statements. Defendant seeks permission to elicit statements made to the media and on social media by the Attorney General and the Director of the FBI. The government responds that while bias is broadly admissible on issues of credibility, neither the Attorney General nor the FBI will testify in this case. Without more, I agree with the government. The defendant should not be permitted to inject national political figures into this trial. Any slight probative value of this evidence is substantially outweighed by the danger of unfair prejudice, confusing the issues, and misleading the jury. Undue delay. Defendant's motion is denied. Ah. She's just laying stupid groundwork for nothing. I know, right? It's a waste of time. Waste of time. And a waste of paper. But thank you, Hannah Dugan's lawyers, for helping me with content, because I get to make fun of you. And I get to get paid while I'm doing it. I mean, not very much. It's like pennies, but still. Better than, working a 9 to 5. Audio recordings and transcripts. Defendant moves for an order requiring the government to produce the full transcripts of audio recordings and identify the portions of the audio recordings it intends to introduce. This one I had a problem with because, yeah. But they might bring in an expert layman. I know, right? So many things to say about that, none of them YouTube appropriate. The government responds that if it anticipates producing final versions of the enhanced recordings and transcripts to the defendant's defense as soon as those items are finalized, and certainly in advance of the pretrial conference. The government will also identify relevant excerpts of the recordings in its exhibit list. Once again, she's asking for things that they already agreed to. The request should be denied as moot. She's asking for things. She is creating content because of basic stupidity. Yep. Oh, Timothy, how are you? Oh, Timothy, refer back to the first 5 minutes of this stream. There's some interesting, probably. Rule of completeness. Defendant seeks an order allowing her to introduce the complete recordings or transcripts of audio recordings in response to the government introducing partial versions. In transcripts under the rule of completeness, the government responds that it did not object to the introduction of any portion of the recordings inside courtroom 615 on the morning of April 18th, that it satisfies the requirement of Rule 106. I will address the issue at trial. Grand jury materials. Defendant seeks requiring an order to produce grand jury materials at least 2 weeks before trial. This is another one that was stupid. The government responds that before defendant filed her motion, it had already been agreed upon to provide applicable grand jury materials to her counsel by that date. The government therefore has no objection. This request is granted. Like, stupid. Squid gets minimum wage dealing with complete incompetence and lack of common sense. Yeah, but I could call them stupid and say that they have no common sense, which I wouldn't if I was acting in a professional capacity. But the professional capacity is on my other channel. Here we're semi-professional, but we call the BS where we see it. Over there, that content has nothing to do with any hot topics. So that is all professional all the time. So, in college, I didn't drink. I was always designated driver, but I loved to go out for dinner and beers, then go bowling with everyone. I'd bowl left-handed as a handicap to match their beers. Oh, I got a story for that. Yeah. I used to go to the base club. It had like 14 pool tables, 12 pool tables, something like that. I used to practice right-handed. I'm left-handed, and would get the stupid guys coming off the ships thinking they were hot shit. So I'd shoot right-handed, play a game with them, shoot right-handed, completely suck. Asked them if they wanted to play for $20 and switch to my left hand. So, and then she just concludes to basically repeat what she just said. That was 21 pages of fun. In an hour, we did 21 pages in an hour. We did all right. So we have And thank you, Roy, for putting the thing to my the link to my other channel. I did not record a video over there this week. Shh. Yeah. I started doing that at like 7 years old. Ask my dad. Um, my, I started hustling people at the pool table at a very, very young age. Ask my father. He can confirm. Do. And then um she had this wonderful order. Uh yeah, pretty much. I would practice with my right hand because I get better with my right hand because I didn't like to have to either shoot behind my back or like sprawl out across the table, especially because I'm so short. So I learned to make certain shots with my opposite hand. So I was actually practicing and they just happened to be stupid. And Harry, thank you for the $2 super chat. Candy for Little Squid. Thank you so much. We went to Walmart and Hobby Lobby today. So we got more stuff for the tree. I'm putting these on my tree this year. Me poinsettias. I'm going fancy this year. But now I'm getting glitter everywhere. Ah. Hey, Magic Angel. Hey, Squidly. How is sweet little Squidly? She's good. I hope your Thanksgiving is wonderful. She's hanging out with her dad right now. All right. So this is just the fun little order. It is ordered that potential jurors be partially sequestered during jury selection on December 11th and 12th, and the selected jurors be partially sequestered during the trial set to commence on December 15th, and that lunch be provided. There's no courthouse cafeteria are compelling reasons to provide lunch. Even lunch needs judicial oversight. She's oh my goodness, Jeffrey, stop. Oh yeah, and if expert happens to watch this, go Vandy. I still love you, but go Vandy. Yeah, that mommy's ring be found. Yeah, I still can't find my ring. No, that's what mommy wants from Santa this year. You know. Yep. And there's there's where remember how I always tell you that no matter how big my ego seems to be on this stream when I'm like, "Oh yeah, I was good at this or I was good at this." How sometimes my parents will just message me and bring me back down to size. Welcome bringing me back down to size. You were a good pool player, but I was a great pool player. Yes, you were, Dad. Yes, you were. Yes. Thank you for putting my ego back in check. Appreciate that. I needed it. All right. So even lunch has to be legislated. So there is one thing. Oh, please say I didn't close it. Nope, it's right here. This one I did not save yet, so I am saving this document before so I don't have to I am saving this document so I don't have to pay for it again. This was today. 28th. So 25, 11, 28. So the way I file these things, if I ever send you a document or you ask me for something or I look confused, the way I save things is I save it by the year, month, and date, and then the document number. So this is document 75 of this trial. Dugan letters. And I need to save it to the right spot because, it doesn't do any good if I save it to the wrong spot. Then I get confused. Hey, Wolfgang, Ricky. We call them doors in Nashville. Squid phrase being anchored down. Rays would be anchored out. Oh, I will be watching the Georgia Tech game, but out of if I have to choose between those two teams, let's go Vandy. I never thought that we would be having this conversation where Vandy has a better record than Tennessee, but here we go. Window, boop, there we go. All right. Nope, hold on. I have to stop that for a second. There we go. It's great you're using your brain. That's a criminal offense. And hey, Ketchup, how are you? Uh, for those of you who are just joining us, tune in to the first 5 minutes of the stream. It's very well worth your time. If you haven't seen it, somebody violated their parole. Not me, obviously. All right. So this is a letter to the judge. At final pretrial conference on November 26th, the court asked the parties to address the government's motion to exclude testimony from the defendant's proposed expert witnesses. And I have not read this yet. This literally, I checked the docket 5 minutes before I started streaming, and this was there. It was not there this morning. From the defendant proposed expert witness, that issue related to the question still pending before the court about how to define proceeding in the jury instructions. That'll be up to the judge. The attached supplemental authority may aid the court's consideration of both issues. See U.S. v. Hernandez. Eastern District of Virginia, January 2nd, 2024. In Hernandez, the defendant was ordered removed pursuant to a final order of removal in December 2019. In May of 2023, he was taken into the custody of ICE, awaiting his deportation. The defendant escaped from ICE custody after he was reapprehended. The grand jury returned an indictment charging him with obstructing a proceeding in violation of 18 U.S. Code 1505. The defendant moved to dismiss the indictment, arguing that the 2023 execution of the removal order was not part of the proceeding. He argued that the proceeding ended upon the issuance of the final order of removal in 2019. In support of his argument, the defendant relied upon cases interpreting official proceeding as used in 18 U.S. Code 1512. Oh, they're really are. I mean, I understand to a point it has to be done. It has to be done. But at the same time, are we really arguing over the word proceeding? Like, let the judge figure it out and stop trying to. Why is she trying to take power from the presiding judge and basically telling her how to? It's her. The Judge Adelman is a Lynn. The judge is a woman, so I think that's one of the other reasons that she's trying to do some of the stuff she's doing is that it's a female judge, and this judge is not having it. This judge is like, nope, not today, Satan. Not today. Come on. I keep getting notifications and I don't know why. The court rejected the defendant's argument. The court reasoned that cases interpreting 1512 are no help because 18 U.S. Code 1512 covers only obstruction of official proceedings, whereas 1505 covers any pending proceeding. It found that if Congress intended for 1512 to require a certain formality that 1505 does not. Cases interpreting statute 1512 are thus opposite because none purport to define the operative standalone term proceeding as found in 1505. Oh my god, this is giving me a headache. Because this is an ex parte letter. This is not this is a letter from her lawyers. This is not a motion. So no need for the double spacing as in a motion and how that is arranged. This is see ya. If if a president could argue the meaning of is, then yes, she would argue the meaning of proceeding. The only argument I've ever had over a word is may versus shall. Like we've seen in some of the stuff in Florida. It may be this, it's not, it shall be this. Yeah. And Gail, I hope you feel better. I'm kind of stuffy today. Trying my hardest not to get sick. The court instead relied on the model definition of proceeding in 1505 from the Eighth Circuit's decision in Rice v. U.S., which the United States also relied upon in support of its proposed jury instructions. The court explained that a proceeding is a comprehensive term meaning the action of proceeding, a particular step in a series of steps adopted for accomplishing something. The court thus held that the term proceeding in 1505 includes the step of executing a final order, including ICE's execution of the final removal order of the defendant, citing proceeding in Black's Law Dictionary. Hey! And lurker, no lurking, and yes, I had small kids at one point who loved Dora. Oh my god. So this morning, Mo, Shizzy, and Volstorm, Mo was playing some video and they were doing like a play of Dora, and it was like the second funniest thing I've ever seen in my life, only first to their sword fighting skit just prior to that. I highly suggest you go back and watch Mo, Shizzy, and Volstorm stream this morning on Mo's channel, because it was it was something else. It was something else. It was hilarious. Hey, Christine. Oh my God, Roy. Let's ugh. The defense contends that her proffered expert will testify about facts, but he was not personally involved in the execution of EFR's removal order. He would rather testify as an attorney about the questions of law that are for the court to decide. The defense seems to concede that this is a question for the court because the definition of what legal definitions and defining things are a matter for the court to decide. Oy. The defense seems to concede this a question for the court by proposing an instructions which the court would decide as a matter of law that executing a federal agency's arrest warrant is not a proceeding. The case law interpreting 1505 supports the opposite conclusion, which is why the U.S. has requested that the court instruct the jury consistent with that case law. The U.S. is prepared to present testimony from ICE personnel who will describe a series of steps to which they were personally involved in the reinstatement and execution of EFR's final order of removal. Testimony from an attorney who is not personally involved with the execution of those steps will do nothing more than testify about the law, which is a province of the court. This is from Brad Schimmel, U.S. attorney. Hey, Dad. Dad, didn't Brad Schimmel run for state Supreme Court in Wisconsin at one time? Or am I just losing my mind? But I know that name from somewhere. I know that name from somewhere. Let me do some research on the fly here. Brad Schimmel. Former Wisconsin Attorney General. Maybe that's why. He is currently interim U.S. Attorney in Wisconsin. Oh yeah, former Supreme Court candidate Brad Schimmel. So, yeah, and he lost. Okay. That's what I thought. I just couldn't remember. I thought I knew that name from somewhere. And this is the case law that he is citing from Westlaw. And I don't have access to Westlaw, so I'm not that important. This is just basically the case law that he described in that letter. And I'm not going to read all the case law because I don't think anybody I don't think anybody wants to hear that. Um, but on that note, that is all. Thank God that I have today. We do have some other things coming up. I need to cut this down and make a couple videos out of it. I also have, as you can tell, like I haven't even done my hair. Um, the um, I need to do some stuff for the other channel. I'm helping some people with some stuff tomorrow, so we may do a members only tomorrow, but it's doubtful. Um, Sunday will be Sunday at 5 p.m. We'll be live on the other channel, even though I haven't uploaded anything. We're gonna be going over some stuff, seeing how I research, um, Q&As, going through my new going through the new link tree to see the things because I have some of you guys emailing me and asking me questions, which is great. I don't mind it. I don't care. However, I did set up a free one-on-one in there so that if you want to email me, but you are afraid you can't describe it very well and you want to do a face-to-face, I do have a 30-minute totally free. Like I'm not charging for any of this. Like it's not even that. Um, but instead of trying to email me and describe a situation, we can just talk about it. So I can't do a spicy naughty Sunday while going to town anymore. Almost got me thrown in jail. Oh no. But about 5 p.m. on Sunday, will be my live on my other channel. We'll just be doing a Q&A talking about what will be coming up. I couldn't do a video this week. I completely forgot to build into the schedule the fact that, this week was Thanksgiving and like there are things going on in life. So this week's video will be next week, but we will careful with those one-on-ones. I can see those going sideways. Well, it's built in. You have to schedule a time. So you have to schedule a situation. So you have to schedule something. It's not like that, Jeffrey. Stop going there. But y'all have a great day. I will see you guys on the next one. Let me see if there's anybody with a stream set up or who is already live so that, and I lost 2 subscribers during this stream. Interesting. Oh, must be a. Oh, and thank you to the one person who hit the thumbs down. Oh my God, I love this shit. YouTube is so funny with how people do things and make decisions. Y'all crack me up. Nick Starro is live right now, so we're gonna go over there and say hi to him. Y'all tell Nick I said hi. So slightly buzzed Friday show with guests. I don't know who his guests are, but your fault? No, probably not. There's always YouTube always pulls some stuff. And plus people just are funny. But y'all have a great night and I will see you on the next one. Bye guys.